Supreme Court of India Maharana Pratap Singh vs. the State of Bihar and others decided on 23th April 2025 0 NSC 554 facts of the case. The appellant was appointed as a constable. He proceeded on earned leave for 2 days, with the intention of resuming his duties on August 8, 1988. Incidentally, on August 7, 1988, FIR for offences under sections 392, 387, 420, 342, 419 read with section 34 of IPC was registered on the complaint of one Prem Kumar Singh, informant against unknown person. Subsequently, the appellant was arrested and was brought police station. On the same date, i.e., August 8, 1988, the appellant was placed under suspension by his superior authority. The memorandum, duly served on the appellant, inquiry officer find the appellant guilty of the charges leveled against him. Appellant was dismissed from service. The appellant was found guilty of offences under sections 384 and 411 of the IPC and was sentenced to undergo simple imprisonment for a period of 1 year. However, he was acquitted of the charges under sections 392 and 419 of the IPC. The additional sessions judge set aside the judgment and the appellant was acquitted of the charges. Director General, Inspector General of Police, CID upheld the dismissal order. High Court single quashed the dismissal and directed the respondents to grant the appellant all consequential benefits from the date of dismissal. Division bench dismissed the writ petition. Findings of the court: on perusal of whatever is available on record, it is found that allegations have been leveled against the appellant under 4 distinct charges. A specific objection having been taken on behalf of the appellant that the charges were vague, indefinite, not specific, and lacking in material particulars, we felt it all the more necessary to have a look at the nature and wording of the charge sheet from the departmental file. However, in view of withholding of the departmental file, the presumption that can legitimately and validly be drawn, and which we do hereby draw, is that the respondents did not deliberately produce the departmental file lest the illegality in proceeding against the appellant from the inception is exposed. Based on the foregoing discussion, the version of the appellant that the charges drawn up against him were vague, indefinite, unspecific, and lacked essential particulars has to be accepted. If there is a flaw from the inception of the disciplinary proceedings, i.e., the charge sheet is not issued conforming to the relevant rules and the charged officer finds it difficult to meet the charges because it is vague, indefinite, not specific, and lacking in material particulars, the charge sheet itself becomes susceptible to vulnerability. Moving further, the appellant had raised an allegation that prosecution witness -1 was not allowed to be cross-examined. Rule 55 of the Rules of 1930 provides that the witnesses may be cross-examined by the charged individual. Had the departmental file been placed on record, it would have facilitated a more thorough analysis of this sub-issue. Nevertheless, based on the available material, the question remains whether it can be determined if the appellant was provided with a sufficient opportunity to cross-examine prosecution witness -1, or if the appellant chose not to exercise that opportunity. Nonetheless, we are of the view that dismissing prosecution witness 2 cross-examination as incredible, solely due to the delay in its conduct, would not be a reasonable conclusion. Prosecution witness 2 had also denied the appellant's involvement in the criminal proceedings and, during his cross-examination in the inquiry, he explained that he had previously disclosed the appellant's name based on hearsay from individuals within the department. Upon reviewing the materials at our disposal and considering the aforementioned anomalies in the issuance of the charge sheet and the procedural lapses, none of which can be attributed to the appellant, and in light of the absence of the departmental file pertaining to the disciplinary proceedings, we are compelled to conclude beyond any cavil of doubt that due process was not followed in dismissing the appellant from service, rendering the dismissal unjustified. In light of the preceding discussion and the adverse presumption that is available to be drawn, we hold that the finding of the appellant being guilty of charge number 1 cannot be sustained following his acquittal in the criminal proceedings, which seem to have involved substantially similar or identical charges, evidence, witnesses, and circumstances accordingly. This court concludes based on the materials available on record that the disciplinary proceedings had not been conducted against the appellant in tune with principles of fairness as well as natural justice, which severely prejudiced his defense. The impugned order, thus, is unsustainable. Having bestowed serious consideration, we are of the clear opinion that ends of justice would be sufficiently served if we direct payment of a lump sum compensation of Rs 30 lakh to the appellant inclusive of all service and retiral benefits by the respondents within 3 months from date. Ordered accordingly, the appeal, accordingly, stands disposed of.